Hi, my name is David Moss, speaking on behalf of the NAACP Legal Defense Fund, LDF. We're also a proud member of Communities United for Police Reform. We thank the committee for this opportunity to testify on Intro 586 and 538, the How Many Stops Act, and we strongly urge the Council to pass these important bills. In 2010, LDF, the Legal Aid Society, and the law firm Paul Weiss filed Davis v. City of New York, which challenged unlawful stops and arrests in NYCHA buildings. And after a settlement, these issues became part of the federal monitorship in 2015. 8 years later, we are still concerned by racial disparities and unlawful police activity, and these bills will shed light on the full scope of police conduct that impacts Black and brown New Yorkers every day. I'd first like to note at the outset that police are not allowed to randomly enter and patrol private residential buildings, but they are allowed to do this in NYCHA buildings. In fact, they're directed to by the NYPD Patrol Guide. This policy creates a second-class citizenship for many NYCHA residents who live in the constant presence of police. They face far too many police encounters and far too many unlawful stops. And according to a recent study by the Monitor, 1 out of every 3 stops in a NYCHA building is unlawful. 1 out of every 3. Furthermore, Black people make up 71% of people stopped in NYCHA buildings. As you know, police currently only report on level 3 stops, which involve a detention. But level 1 and 2 stops do have a strong impact on people's lives, and they should be reported as well. Level 1 stops can be very invasive. They can target children. They can often be used as fishing expeditions. And police often escalate these encounters into more serious encounters. And in fact, the Monitor has found that improper escalation by police is a problem in NYCHA policing. Level 2 stops allow officers to target people for extended and accusatory questions without reasonable suspicion. These are extremely intimidating encounters. People often feel as if they are being detained without reasonable suspicion, as the public advocate aptly pointed out. You know, it's a very blurry distinction between level 2 and 3, and police do not have to report about these currently, so that does need to change. Now, there may not be documentation from these level 1 and 2 stops, but they do leave a very profound impact. People end up feeling violated, communities feel persecuted, not protected, and as always, Black and brown New Yorkers bear the brunt of this burden. Now, as for consent searches, these are extremely common, one of the most common types of warrantless search, and they create staggering racial disparities. Last year, there was over 5,000 consent searches in New York City. 88% of all of those consent searches were of Black and Latinx people. Only 4% were of white people. So we do need to know about all the requests that are made, not just the ones that are granted. If police are consistently trying to gain access to Black and brown spaces without a warrant, we need to know that information so that policy solutions can be crafted. So together, these bills, you know, they're likely to reveal more about racial disparities in policing. They'll likely reveal more about unlawful conduct, and we cannot hide from that information. We need to seek it out so that we can work towards a more equitable city for all. Thank you.